And this morning, those three judges issued their unanimous ruling. And they found that the order, the Rook order, that warrant of sorts, that court order that the cops used to arrest Artur Pawlowski, they found that that court order was invalid. It was impermissibly vague. It was useless. No one could rely on it. They struck down the order that started all of this. And therefore, all the fruit from that poisoned tree, the shock and awe, brutal arrests, the jail after jail after jail, Adam Germain's word ban, the fines, every shred of it was thrown out today by the Alberta Court of Appeal. And that was only possible because of you, because you and thousands of people like you chipped in $50 or $100 or $5 or $1,000 to pay for top-notch legal talent that fought with Arthur every step of the way, and that, by the way, is still engaged in defending Arthur from other abusive prosecutions. Today, the legal system slowly and costly finally vindicated Artur Pawlowski, throwing out his convictions, throwing out the order, and condemning by name that partisan judge, Adam Germain, and throwing out the underlying order. And I'm delighted to have on the line with us now from Calgary the lawyer who deserves so much credit for today's win, a passionate civil libertarian. You know her from her reports on Rebel News as she was interviewed by many of our talent. I'm talking about Sarah Miller with the leading litigation firm JSS Barristers. Sarah, congratulations again. I'm so pleased, and I say this in the most generous and friendly way. I'm so proud of you. I'm so proud of what you've achieved for our country and indeed beyond our country, because Artur Pawlowski has had the support of people around the world, and that support came down to you and your team, and you were there in the Court of Appeal, and today you had an utter win. So I thank you, Sarah, on behalf of our viewers. Oh, I think you're on mute there, or maybe we.
Thank you for having me, Ezra.
Well, it's a pleasure to have you. Now, I know you're under the weather. I'm under the weather too. I came in because I thought this was such an important story. Now, listen, I'm more political in my language, and I know you would never say the words that I've just said about the police, or indeed about Judge Germain. And that's one of the reasons you're so effective, because you're a disciplined professional lawyer who went into that Court of Appeal, head held high, and you made the case based on the facts and the law, not just on emotion and not on politics. You went in there in the law. Give me a minute on that. This case is about Artur Pawlowski, but it actually sets a precedent that could have gone a very different way. For the government to have such enormous power to order people to make compelled speech, to order them to condemn themselves, to put people at such risk of vague court orders. Artur Pawlowski, his liberty was in the crosshairs, but you actually, I think, fought for every Canadian of every political background. That's my view. Tell me what you thought of it.
That's exactly how I was approaching it as well, Ezra. So the issue that I really saw with the decision that Justice Germain made when he first made the finding of contempt was extremely concerning, and for a number of reasons. The core reason that I thought was the most concerning was it really attacked the division of powers that we have in this country. So we have laws that are made by different actors, right? We have laws that are made by our elected representatives, and they create things like our Public Health Act. And so in Alberta, we have elected officials acting in government, creating this structure of the Public Health Act. And the Rook order, as interpreted by Justice Germain, made it so that the Public Health Act and the fines and sanctions made under that were no longer in effect, because now we've got this new order, this new approach of how we're going to police and monitor our citizens. It overreached. It was an improper and inappropriate approach to injunctions. As far as applying it to the Pawlowskis or interpreting it so it should apply to all Albertans everywhere. And it was a concerning precedent. I am so thankful that we were able to go to the Court of Appeal thanks to the contributions to the Democracy Fund, so that we could make sure that that kind of precedent does not remain the law in Alberta. And thankfully, the Court of Appeal has agreed with us and has struck down the decision by Justice Germain.
All right. Well, you said a lot of interesting things there. I want to break this apart. Do you have about 10 minutes with us, Sarah? Because I want to get into the meat of the ruling. Now, Olivia, I think you've got the ruling there. I'm looking at paragraph 53 of it. Now, Sarah, I'll read it out in case you don't have it in front of you, but I know you know this ruling pretty well. So what we had is a couple of different problems, and frankly, you were victorious in all of them. We have the compelled speech issue, which is just so odious to me. But the reason Arthur got caught in this trap is he was handed a court order from this Judge Rook that didn't have his name on it, didn't describe him or exactly what he did. And so I'm going to read a little bit from the Court of Appeal's unanimous ruling today. I'm going to read paragraph 53, so give me about 1 minute to read the text, and then I'd like to invite you to explain, maybe in plain language for our viewers, why this is so important, why having clear court orders protects all of us against overreaching police and, frankly, overreaching judges. So let me read a bit of paragraph 53. When determining who is subject to an order, that means who's bound by it, the words used in the order must be clear and, like the language of a statutory instrument, are presumed to have been included for a reason. There are two aspects to paragraph 1 of the injunction: identifying the persons to which the injunction applies, identifying the nature of the prohibited conduct. And I'm just going to read a few of the details there. Shall be restrained anywhere in Alberta from organizing an in-person gathering, including requesting, inciting, or inviting others to attend an illegal public gathering, promoting an illegal public gathering via social media or otherwise, attending an illegal public gathering of any nature in a public place. And then I'm just going to read paragraph 54. It is the first aspect of paragraph 1 that's at issue here. The injunction does not state that it applies to all persons with notice of the injunction, nor to all persons with such notice, including the named respondents, which is essentially the interpretation. There's some technical language here. But I don't want to get bogged down in the wording, but you understand the gist of what I'm talking about here. Clarify this. Does this mean that a court can't just name the vast swath of people without particularizing what you have to do wrong to be in breach of the order? Am I right on that?
Yeah, so we're dealing with two steps here, right? The first step is what Alberta Health Services did, which is go into court and ask for an injunction to constrain some sort of behavior. The second step is, okay, well, if you breach that order, can you be held in contempt of it? So in theory, the order as it was obtained can be done. But if you want to find somebody in contempt of the order, that's never going to work for you. The way it was drafted, the way it was written, the way that it was obtained, according to the Court of Appeal, won't work. So an order that is going to constrain an Albertan, their ability to move and do things and gather with people or say certain things on social media or encourage people to attend a gathering or even just promote it by retweeting or anything like that, needs to name people specifically. You can't go in and get some vague language about people acting under their instructions or independently to like effect and think that those words are going to capture any Albertan and prohibit them from doing things. So we see this in environmental protesting. We see this in Indigenous protesting. You need to name the people specifically, or if you're doing, a John Doe, Jane Doe situation, that's still permitted, but you need to be really specific as to who is going to be captured under this order. And that's what the Court of Appeal is saying here. Yeah,
I mean, let me just read one more paragraph, and I'm sorry I chose one a minute ago that was a little bit technical. I'm going to read paragraph 59, because this is sort of their summary of it. Where there is ambiguity in a phrase that purports to identify a group of individuals to whom an ex parte injunction applies. And by the way, ex parte is Latin. It means without that person there. So Alberta Health ran to court in secret. They didn't tell Arthur. They didn't tell you, even though they knew you were on the file for Arthur. They ran into court secretly and convinced a judge to issue this order. So they have a high burden of being fair if you're sneaking into court and not letting the other side know. So Here's what the Court of Appeal said today. Where there is ambiguity in a phrase that purports to identify a group of individuals to whom an ex parte injunction applies, the injunction may not be sufficiently clear to found contempt proceedings against such individuals for breaching the terms of the order. As all elements of contempt must be established beyond a reasonable doubt, and here's the line, we conclude that the injunction here was not sufficiently clear and unambiguous when it referred to other parties, quote, acting independently to like effect, so as to apply to the Pawlowskis. The contempt finding against the Pawlowskis must therefore be set aside. So that's really the nub of it, isn't it?
Yeah, exactly. And it's really important to hold especially a government actor to a really high degree of specificity, because as you said, they went in not only without giving us notice, but they went in on their first day in court, May 5th, 2021, and had the matters proceeding in camera, which means there was no court recording. Usually you go into court, I couldn't convince a judge for the life of me to turn off the recording and let us speak privately without it being recorded. It's a public institution. It's there for the public. I'm going to be recorded when I'm in court. May 5th, 2021, Alberta Health Services goes into the court and proceeds in camera without court recording. We have no idea what was said between them and the judge. They go back on May 6th. Again, still no notice to me, still no notice to the Pawlowskis, no notice to Christopher Scott, who is named in the order, no notice to his counsel, who Alberta Health Services was aware of, and gets this order, which is very vague. And that's why you want to give notice to the other side. The other side sits there and goes, well, this doesn't make sense. Where is this going to go? We look at things when we're looking at somebody else's work product in a more particular way. Alberta Health Services got this order. They didn't turn their minds to, I guess, how it was going to be interpreted, or thought that it would be so vague and broad that they could apply it to anyone. And the Court of Appeal has said, no, you can't do that.
You know, one of our mottos at Rebel News is telling the other side of the story. We believe that there's more than one side of the story, and we should hear from both sides. That's not just a journalistic rule of thumb. That's actually a precept in the law. In Latin, they say, audi alterum partem, hear the other side. Hear the other side. Maybe they know something that would enlighten us. Maybe we're missing a trick, right? Hear the other side. The clash of two passionate parties and a neutral judge in the middle sorting it out. So if you have a secret meeting where the other side is not invited, and I didn't know what you just said, that they literally turned off the recording. I've never heard of that before. Even in cases where there are minor children and there's a court publication ban to protect the identity of the kids, they don't turn off the recording. They just make a rule, hey, journalists, you can't say the names of the kids. I have never in my life heard of a recording being turned off so you could have a little secret justice. That reminds me of the Star Chamber in medieval times. But at least in the Star Chamber, you were there with a lawyer. I didn't even know how bad that was. And that's the thing. I mean, I'm a little under the weather, so I'm not as high energy as I'd like to be, Sarah. But I started the show today with the first thing I saw very early in the pandemic, when the cops were pushing around Arthur when he was feeding people in the snow in Calgary. And that's what got under my skin. I thought that's not right. They're picking on this guy. And so we retained you. That was in April or even March of 2020. And so by the time this Rook order, and by the time the Nazis out, and by the time the shock and awe SWAT team arrest happened, you had been working for Arthur for a year, right?
Over a year.
Yeah, so you had interacted with the government by phone, in person, by email, by fax, in court. So they knew you. And for them to pretend they didn't know you, pretend they didn't know you were on the file, and to go to court and have a secret huddle with a judge, and then serve this order on Arthur instead of on you, and then arrest him in the street like he's El Chapo, instead of just saying, hey, Sarah, you know what? Can you bring him in? Can we arrange for a time where you can bring in Pastor Arthur, because we are going to charge him. Can you bring him in? Like, for them to pretend that you were not on the file is I believe that's unethical. I believe that's sharp practice. I believe that there was so much bad behavior here by the government. And once, okay, you make a mistake. Twice, maybe you're exuberant. But again and again and again and again and again, I really feel like this was a government vendetta against a man they just, so will someone save me from this turbulent priest? I believe that they hated this man so much that they justified it in their mind that they would break any ethical and legal norm to get him. That's how I feel.
Yeah, I think it's very easy once you let your emotions get involved into something to forget what your role is as an to the court to bring all the evidence forward. When you feel like somebody is so very wrong in what they're doing, it makes it very easy to turn off that filter in your brain to say, I'm not going to be concerned about that, or this is right and vindicated in some way. I don't know that anybody at Alberta Health Services really went out to act inappropriately or to ignore the laws and rules and principles that we usually use to guide ourselves. But I am certain that they were motivated by emotion and by a misplaced sense of righteousness. And they forgot to keep their filter on to say, what is the legal analysis here? What are my duties here to the court? And what are my duties to people in Alberta to make sure that people who I'm not thinking about right now in my anger are going to be captured by and subjected to this order. So we know that there was other pastors arrested that same weekend with Artur and David. And I just wanted to mention one other thing. As you said, they served Artur. They never actually even served him.
Huh.
He was running his church the whole day. He never received service of this order at any point during that whole day. It was served on David, who, of course, didn't understand what he was being served with because he had never heard of this and didn't know what was happening.
Yeah,
and the police couldn't be bothered to explain it to him.
And there's technical language in there. I mean, he's an immigrant. English is not his first language. The law, which is a technical English, is not his first language. He has a top-notch lawyer, but they didn't give it to you because the whole thing was cut any corner necessary. You know what? I quoted that line. Whoops, I'm going to turn my phone off. I quoted that line. It was Henry II who said, will no one save me from this meddlesome priest? And they killed Thomas Becket. They killed the priest. It's not new for politicians just to... And why do they hate the clergy? Because the clergy are obedient to a higher power. Most churches closed their doors because Jason Kenney told them to. Most did. But a few true believers, some in Edmonton, some in Calgary, just refused to. And that's a real power struggle. Am I not the king? Am I not the king? Will someone save me from this meddlesome priest? And 4 men said, okay, I better damn well save the king from this meddlesome priest. They went and killed Thomas Becket, the head of the Church of England. I think it was the Archbishop of Canterbury, as they called him. Well, who's the boss here? Am I not king? And Jason Kenney couldn't get this meddlesome priest to bend the knee. So they got him to bend the knee on the street, didn't he? He bent the knee on the street. All right, I'm mad. Sarah, I got a question for you. What other cases are proceeding against Artur Pawlowski and his brother David?
Well, there's quite a few. So related to this decision that we had from Justice Germain, that's now been struck. But while they were under that probation order, both of them were charged with breaches of probation. We've entered not guilty pleas to those charges. There's all sorts, before this was set aside, there's all sorts of issues with those charges, but both of them were charged with breach of probation. Artur Pawlowski has also been charged with criminal contempt of the Rook Order, which, based on the analysis given by the Alberta Court of Appeal, the Rook Order doesn't apply to the Pawlowskis or Artur specifically, so that also should not be proceeding, but it's still outstanding as of today. There's also a charge against Artur Pawlowski for attending the Coutts border here in Alberta and giving a speech, I guess, or a sermon at the Coutts border during the trucker convoy protest that was down there in February. So he's been charged not only for criminal mischief, over $5,000 for supposedly inciting mischief with the highway, but also under what is legislation in Alberta only, the Critical Infrastructure Defence Act. Now, the unions who, sometimes want to strike, sometimes want to demonstrate, have tried to challenge this act as unconstitutional. They've not been granted standing. They've not been allowed to proceed with their challenge. But it's widely understood that this act is likely unconstitutional. So Artur is the first person that we have been able to figure out has been charged under this act, and so he's charged with mischief and the Critical Infrastructure Defence Act offenses for the February protest.
I got a question for you. All those breaches of probation and all those things that emanated from this, like I say, fruit of the poison tree, it would seem to me that those are all now moot. That's what you suggested.
Yeah, the Coutts protest, not moot, but because it arises
that's a different law. That's the infrastructure law. Yeah.
Yeah, but the probations, they should be moot. So I hope, I expect that the Crown will discontinue those charges for breach of probation against both the Pawlowski brothers, and as well the criminal contempt proceedings for Artur Pawlowski should also be discontinued based on this decision. So, but Artur has been subjected to arrest, detention, David too, arrest, detention, and outstanding criminal proceedings for two men who are in their 40s with no criminal record to date, facing criminal charges because of this decision from Justice Germain and everything that flowed from that.
I don't want you to talk about anything subject to solicitor-client privilege. I don't want you to give away any strategies. I don't want you to tip your hand. I don't want you to give any notice to the bastards on the other side. But it is my observation that the prosecution, and I would say persecution, of the Pawlowskis was not normal, that it would not have been abided by a normal prosecutor, that there were decisions made at higher levels. You don't have a 8-car, 15-cop takedown of a guy on a highway without that being approved by senior police brass. I'm sorry, it doesn't happen that way. You don't have a hunter-killer team of dedicated police, Alberta Health Service officers and prosecutors going church by church. That's a special vice squad. I believe that there was a higher level of operation here, a political level of operation. Like I said, I've never heard of a recording being turned off in a court before. Never heard of that. Never heard of that. I believe that there was malicious prosecution. I believe there was abuse of office. Now, I know that just because you lose a court case doesn't mean there's malicious prosecution or abuse of office. Courts are allowed to get it wrong, and the way you solve a wrong court is with an appeal to a higher court. So Justice Adam Germain, I think he's a disgrace. I think he should resign. I don't think he should have been put on the bench in the first place. I think he discredited his name for all time. But that's not a criminal. That's not necessarily even unethical. That's to be corrected by the higher court. And indeed, he was slapped down pretty hard today. So I'm not saying just because someone got it wrong that there was malfeasance. We're humans. We're allowed to get it wrong. But there is a 20-year vendetta against Artur Pawlowski. You've been on his file for 2.5 years. I happen to know that he's been fighting with City Hall for at least a decade before that. And they just can't stop hating him. And it infected the last mayor of Calgary, the police chief. It infected Jason Kenney in the cabinet. I do not believe that the persecution and the prosecution of him was normal. It feels like the kind of obsession that governments have with, I'll just pick a name, Julian Assange. Obviously a different species altogether. But it feels so obsessive. It's not normal. Are there any tools that a thoughtful, professional, ethical, fact and argument-oriented lawyer could use, and don't give anything away here if it's private, but I just feel like a court of appeal ruling, it feels good, but good Lord, the guy had to go through 2 months in prison, high six figures in legal fees, humiliation on purpose. Is there nothing more for him? Can there be some sort of inquiry? Can there be some sort of comeuppance and investigate? How did this get so wrong?
There's a few things that could be considered going forward. One is, as you indicated, a tort action for malicious prosecution and abuse of position. So that's certainly an option. Those are not easy cases to make out. As far as the wrong decision by Justice Germain, that, as you say, the remedy is go to the Court of Appeal. Getting the law wrong, applying the law wrong, interpreting the law wrong. Courts of appeal overturn decisions all the time, so there's not a lot we can do there. But arguably, the action of either Alberta Health Services or the Crown Prosecutor's Office, depending on how the next few days play out, at least with the Crown Prosecutor, could attract at least a consideration for the tort of malicious prosecution. As I say, it's not an easy case to make out, but certainly in this, from our perspective, this was so clearly something that should have never gone to the first hearing date. Police failed to give proper notice. They arrest, they detain for 3 days, 54 hours or something. So nearly 3 full days, and they release him with no conditions, really, keep the peace, be in good behavior type. And then for Alberta Health Services to pick up the mantle from that mistake and to continue it through bringing multiple witnesses, through combing through his social media for months to give additional little tidbits to Justice Germain to feed on, or bringing irrelevant evidence into court, failing to comply with the rules of court regarding hearsay or regarding, splitting the case or bringing certain evidence at certain times. All of those things are very concerning. It's either an indication of, as I say, forgetting to keep that filter on with respect to not being motivated by emotion. But that emotion feels like malicious emotion. Now, whether a court would agree with us when the test is so very high and there's going to be feelings on both sides as to, well, are you allowed to dislike somebody who is so loud and open and abrasive as Artur Pawlowski? It might not be the easiest case to bring, but it's certainly something available.
Once in a while, people call me irritating and annoying too. It's very rare. I'm always shocked to hear it, but thank God, being annoying and irritating and sandpapery is not a crime. And I think that, it's funny. I have some family from the former Soviet Union, and they told me that the people who would get into trouble with the authorities were not normally political dissidents. There were very few of them. It was just people with quirky personalities that were irritating, that bugged people, that maybe were on the spectrum, or that it was a personal slight. The people who were always in trouble with the KGB were quirky people, annoying people. And that was the ultimate way of solving a problem, is rat someone out or snitch on someone to the secret police that you just hated. That it wasn't that they were democracy activists in Siberia or something. It's just someone who rubbed a powerful person the wrong way. Artur Pawlowski has a very strong personality. He's not meek and mild. He uses the lion metaphor, and he tells his people to be lions against the hyenas. That's very different than other church leaders in Alberta being prosecuted. Be wise as serpents and gentle as doves. There's doves out there. Arthur says he's a lion. That's not a reason to throw a lion in a cage for 50 days. I want to tell you why I'm sitting here, Sarah. I got a text from a cabinet minister who either looked at my tweets or is watching this program right now. Now, I respect the fact that he texted me directly, and so I'm not gonna I'm not going to quote it because I think it was sent to me in some confidence. It was a rejection of some of my points that this was politically motivated. So I wrote back to this cabinet minister, I'm not going to name them, and I said, will you make a public statement about this case? And will you see that this anti-church squad, was it Karen Thorsrud? Was that the prosecutor?
No,
Nope.
So for this particular one that we just got the Court of Appeal decision from, it was actually in-house counsel at Alberta Health Services who prosecuted this whole proceeding.
Got it.
So not any formal Crown prosecutor on this particular file.
Got it. So I think Thorsrud was on another one. I'm just writing this to the cabinet minister. Is there this squad of police and prosecutors who were assigned to this detail? Am I right when I say there's a kind of vice squad, kind of like a gang squad, a drug squad, a vice squad, that there is a squad that's been going on around Alberta specializing in going after the meddlesome priests? Am I accurate when I say that? This cabinet minister challenges me.
So Calgary Police Service created a unit for the purposes of enforcing and acting against anybody who may have been breaching Public Health Act violations. So the city of Calgary, their police force created that unit. We have that in the cross-examination transcripts on this matter from the Court of Queen's Bench. So numerous police officers who provided statements, they had testified that they were part of that unit, that's what their mandate was. They had a somewhat secretive meeting the morning of May 8th, 2021, a town hall meeting of sorts to send out multiple groups and multiple teams to go and enforce the Rook order, which we now know was completely unlawful. It didn't apply to anybody in Calgary that weekend. It applied to the rodeo organizers and participants up 2 hours away from Calgary. So that whole unit has been mobilized to act against Mr. Artur Pawlowski and David Pawlowski multiple times. They also have the city of Calgary has bylaw enforcement that also they have a unit created essentially to respond to what seems to be responsive to the Walk for Freedom marches. So once those started getting up and going and happening weekly with in the city of Calgary, they set up a bylaw service that also triggers it. So at least in the city of Calgary, I don't know what RCMP is doing. I can't say, in all of Alberta that's happening, but certainly it's happening here in Calgary.
I've got some ideas I'll share with you off camera about what to do. Listen, you've been very generous with your time, and I've learned a lot from you. I would encourage our viewers to read the ruling. It's on our website, savearthur.com. We have a number of lawyers who work for Rebel News directly. You're working on this project for the Democracy Fund, which is a registered CRA charity designed to litigate and educate Canadians about civil liberties. And that's very much on point with Pastor Arthur. You've got freedom of speech, freedom of association, freedom of assembly, freedom of religion. There's a lot of really core freedoms at stake. And then, of course, the due process, the fundamentals of just natural justice. So it really is a great case. People who chip in get a CRA tax credit, which makes it easier for people to give. And your fees, which I glance at, are reasonable, and we're grateful to you. But for someone to fight, this is not your full-time job, but I'd say it's probably close to a half-time job for you working on Arthur, and it has been for years, and you have colleagues. You have a senior lawyer there, Robert Hawkes, QC. You've worked with Chad Haggerty, former cop who's now a criminal lawyer. You have staff. So you're the star and you're the leader, but you have a larger team. And I am not going to, for reasons of confidentiality, disclose the total amount we have paid amongst all the lawyers. But it is an enormous fee, worth every penny, because this isn't about money. It's about protecting our civil liberties. But if it were not for the donors and this charity, the Democracy Fund, no normal human could have defended themselves for a 2-year battle, 3 prison terms, hundreds of thousands, let me just put it that way, hundreds of thousands of dollars in legal fees, endless court appearances. I mean, I admire Arthur for his stamina to being arrested, being jailed, and not breaking. They were trying to break him. But no normal person could afford this fight. And even if you were a millionaire, I think most millionaires would say it's not worth it. You know, just pay the penalty, take the loss. I'm not going to spend 2 years of my life and countless hundreds of thousands fighting on a point of principle. I think there's something wrong in the system when it takes a guy 2 years, 2, 3, 4 lawyers, not quite $1 million, to get a little bit of justice, and he's still being hunted.
Yeah, absolutely. I mean, for this case to have been the size and nature of it that the government has brought against Artur Pawlowski and David Pawlowski, that they have brought so many witnesses, that they have tried their absolute hardest to make sure that he was in prison. I talked to other lawyers at my firm who, on a normal matter, everything's contentious, but not civil liberties oriented, a contempt proceeding might take a day, might have maybe 10 pages of written submissions. In this case, we had cross-examinations on 5 different witnesses. We had briefs due on the contempt finding and the sanction finding. We started this process on the contempt finding in May. We had a release hearing. We had multiple hearing dates throughout May, all the way through to October, on something that in other cases could have been a day and 10 pages of written submissions. We have over 100 pages of written submissions, charter issues arising, cross-examination of witnesses, to go all the way through to have a judge find wrongfully against the Pawlowskis and have to then launch an appeal to correct that bad precedent finding, and bad precedent not only for the Pawlowskis, but for all Albertans. And arguably, all of our provinces, we rely on one another. So arguably all Canadians, is amazing that your viewers, that the supporters of the Democracy Fund has been able to make sure that this was not just a steamroll by government overreach, and that we were able to put up the fight that we did and eventually get the win that we got.
Yeah, and credit to Arthur, of course. I mean, it's one thing for me to be a pundit who's mad about things. It's one thing for you to be a lawyer who, as a profession, fights things. But he was the one in the prison cell. He was the one arrested on the street. He was the one who didn't know and still doesn't know how long will this go on for. I was at the Justice Center for Constitutional Freedom's dinner in Vancouver a few weeks ago, honoring Tamara Leach, who's in prison, by the way. And John Carpe, the leader of that group, he's Dutch, and he told me that his grandparents, he told me what it was like in Holland when the Nazis rolled in 1940. And we know now, with the benefit of history and hindsight, that it was, that the World War II ended in 1945. So they had to be able to hold out for 4 or 5 years. But they didn't know that. Was Holland going to be a German province forever? For 100 years? For 1,000 years? Or more to the point, for the rest of their lives? Where do you get the courage to fight against something on principle when you don't know how it's going to end? And Arthur's been in this for years, even decades, and he's not done yet, as you pointed out. So it takes a lot of courage. Salute that guy. He's a prickly pear. He's like an egg. You boil it, it gets harder. The harder you boil, the more you boil an egg, the harder it gets. I think that's him. I just got a note back from the cabinet minister. I called on him to make a public statement. He said, I can't make a public statement on an ongoing legal matter as a minister of the Crown. And I said, the court said the Rook order, I'm chatting with him while I'm chatting with you, Sarah. The court said the Rook order was invalid and the Germain order was outrageous. I think it would behoove you to make a general public policy statement regarding freedom. You don't need to refer to the case at hand. I'm not asking for any cabinet minister or premier to refer specifically to this case, because this case might be appealed for all we know to the Supreme Court. I doubt it will be. And there's other cases involving Arthur. But surely this case is a splash of cold water to those fevered prosecutors and police. I'm going to stop reading from this cabinet minister before I'm tempted to go further. Sarah, I'm grateful for your time. You've spent an hour with us, and I didn't mean to keep you that long, but I'm glad you were here to bring some sober-minded thought. I'm hot, but you're cool, and that's what won it. Cool, collected, relentless, indefatigable is the word I'm looking for. And I don't want to get too emotional, but I believe that you personally played a very important role, and that your qualities, like there are many lawyers in the world, and a number of them could have done it, but it was your personal qualities that I think really made the difference here, some of the qualities I just listed. And you have my personal gratitude. And the reason that so many Rebel News viewers have donated is in part because they've gotten to know you over the last 2 years in your interviews with our reporters. And so they've learned to trust you and indeed to love you because you share our concerns. Even though I'm quite sure we disagree on many political or ideological points, in fact, I think that strengthens our admiration for you because it goes to your belief in principle. And I know that I'll forever be grateful for the fact that you were there in the court. You never said die. You never said blink. You never said throw in the towel. You never said plea bargain. You fought all the way. And I really think you made a difference. And I hope I know you'll get the affection of our Rebel News viewers, but I hope you get it from other fancier people too. I hope you get it from other members of the bar, and I hope you get it from across the ideological spectrum. I hope people on the left who find Artur Pawlowski a pain in the ass, I hope they see how your work in court has strengthened freedom for all of us. And you mentioned some of the other people who've been arrested before in vague and general court orders. They will never know the work that you did, but they will benefit from it. So thanks very much on behalf of all of us here. We love what you've done for us, and we're so glad you're on the team for freedom.
Absolutely. Thank you, Ezra, and thank you to all your viewers who have been contributing and helping Artur's fight and David's fight. It's been a wild ride, and I'm really thrilled that we got the decision we did today.
Well, thank you for that. All right, we'll say goodbye to you, and we appreciate you joining us. I understand you're in lockdown. You got the Rona. May you get back to good health. It looks like you're doing okay, but I hope you're 100% soon. I'm a little under the weather too today. The both of us are quite a case, but you did a great job today. Thanks for explaining things.
Thanks, Ezra.
All right, there you have it. Sarah Miller, isn't she great? I'm just so, I feel so grateful to her. And her fees are what you would expect from a bright young lawyer working on this case for years. I don't begrudge her a penny. In fact, that's the opposite. I believe in this case so much. And so if you want to help us, please go to savearthur.com, because as you heard, there's more battles to come.